Many of us have questions about our next topic, which is sureties and how to prepare them, how to cross-examine them, and the surety affidavits. So we're going to start right now. Good morning.
Morning.
Morning. So I will be watching, I'll be keeping my eyes on the chat. I'm assuming a lot of questions will come in for this panel. But we're here now today to talk about sureties and their affidavits and how to prepare them and their cross-examination. Maybe we can start by talking about surety affidavits and when do we need them? Should we have them? How to draft them properly?
Can I start just by setting a tone around sureties? So I think the first thing we need to realize is the vast majority of people don't need one, that releases are not failing because of sureties or the release. Releases and 90% of the stuff that we're dealing with in court are failing because we've got issues of poverty, we've got issues of lack of services for mental health and addiction. So let's distinguish between all of that stuff and actual serious instances where somebody really needs to supervise. So I just want to put that out as a cultural piece that if we could kind of get there and think in those terms, we might be clearer about how to deal with sureties.
Thank you, Your Worship.
Okay. Yes, that's me. I'm the defense lawyer on this panel. I'm Karin. I'm from Ottawa, so I don't know any of you, but it's nice to be here and hear that you're having the same problems that we're having, I guess, just on a larger scale, but we're all having the same problem. So I absolutely agree, and I wish that we could move away from sureties. We can't. As we all know, the easiest thing you can do sometimes is if you can get a consent release and you have all sorts of conditions you don't necessarily want, and you can get a surety, then your client can get out the same day within a couple of hours. It's a lot harder to, as we've discussed already, tell your client, well, you probably should have a bail hearing. You probably should at least we don't have these triage hearings. This is news to me. But that's a great idea if they actually work properly where you can talk about certain conditions. For myself, I have run bail hearings where I have had a surety available and I have them testify. But my submission will ultimately be to the justice of the peace. You don't need a surety. I have one here in case, but here's my submission, my first tier submission of why this person doesn't need a surety. But if you disagree with me and you really want them to have a surety, here they are. And that has been successful in having someone released on their own recog or what have you. So if you're doing a bail hearing, please don't be afraid to try that venue as well. That aside, the surety affidavit, I did provide one in the materials. I don't know.
We will be sending them.
Okay. So what I do, again, when we have the time, and it really does depend on the case, usually the more serious cases, your surety affidavit is kind of what your surety interview would be. Usually, as you know, you get your surety information from your client. Sometimes the surety is there. They've shown up to court because they found out that the person is in custody. Or if it's a longstanding client and you know them and you say, hey, you know what? I know your mom. I know your dad. I'm going to call them and see if they can come and be a surety for you. So you want to get quite a lot of background information from your surety. In particular, if it's a parent, then they obviously have known the accused all of their life, but sometimes it's a friend, sometimes it's a neighbor, sometimes it's someone who doesn't really know your client all that well. But in terms of the surety themselves, you don't want really any surprises, right? Because I'm sure you've all had this where you've asked the surety, do you have a criminal record? Oh, no, I don't. Okay, have you ever been arrested? Yeah. Okay, so what happened when you got arrested? Because a lot of people don't really associate sometimes being arrested and going through the court system with having a criminal record. But as you all know as well, when your surety is being cross-examined, all of this stuff comes out. Out come all the skeletons from the closet. So you don't want any surprises for you, and you don't want any surprises for your surety as well, because can put them off guard. It can be very embarrassing, and it can really torpedo your bail hearing. So what I do is like I said, I try to get as much detail as possible from the surety, and also what it is they know about the accused person. So again, I have my proposed surety affidavit that I had provided as part of the materials. So and I kind of have modeled it a little bit after your bail review sureties, affidavits, because in a bail review, everybody has to provide an affidavit. So it's kind of modeled on that because these are some of the areas that are important to the court. They want to know who this person is, where they've been for the last little while. I'm talking about the surety. What do they do? Do they have any property? Do they have a job? How are they able to supervise this person? It's very rare you're going to get the perfect surety. I think I've had two. One was a former correctional services officer, and another one was like a pastor or something. But it's rare, and most sureties are just average everyday people, or they are people who are, because they are associated with our clients, they tend to maybe come with a little bit of history. And it's true, there is no such thing as well, there are some, but many sureties are still capable of being sureties, even if they have, a criminal record. What is their criminal record for? How dated is it? How can you sort of turn that into an advantage to have this person act as a surety for your client? So I try to find out, or I do find out, and put it in the affidavit, all those things that you think are going to be important to the court. What's the Crown going to cross-examine on? So obviously name, birth date, where they live, what their income is if they have a job. What kind of assets do they have? Do they rent? Do they own? Are they on ODSP? Are they on social assistance? If they're working, what's their work schedule? How in the world are they going to be able to supervise your client if they're working? People work. If they work 8 hours a day. So I try to get that information in advance and incorporate that into the affidavit. So I would include, I live at this address, I rent or own, I have these particular assets. And the reason you want to get a little bit of the financial situation, of course, is when it comes to posting a bond, what is an amount of money that is going to create a hardship for this person if they were to lose that money? And that's a very valid question that you have to ask these people. If someone has a very limited income, if they're on the line for $500, that's huge for them. Whereas if you have someone who has a larger income, if they're on the hook for, it may be something like $5,000 that is going to, be a hit for them if they had to lose that. So that's the bit of the carrot kind of you have to dangle for people a little bit, and find out what exactly are your means, what are you able to sustain. So again, I obviously include information about the criminal record, whether or not this person has acted as a surety for someone before. And if they have, you want to explore that with them. Who was the person? How did it go? If you have a surety that has previously called the police on the person they've been supervising, then that's a great point that you can always make in your submissions. This is a great surety. They know what their obligations are. They've done it before and they'll do it again. So keep all of these things in mind. I know many of you are experienced and you've done a lot of bail hearings, but for those of you that perhaps are sort of starting out, these are some of the things that I think are important for you to know and to incorporate into your preparations and ultimately into your affidavits. I like to include in the affidavit that the person understands what the obligations of a surety are, and that also include that how long this person has to be a surety. I'm sure you've encountered this where some people think it's only till the first appearance. It's not till the first appearance. Oh, it's only until this day. It's not. It's until everything is completed. And you have to tell them this could be years. This could be 2 years from now. Okay. Are you able to do this? Is this something that is sustainable for you? Is it sustainable for the accused? That's not to say that you can't try to get a variation or get something changed later on, but people need to go into this knowing what they are sort of offering themselves up for. So please keep that in mind. There was some discussion earlier about treatment and things like that. And it is a very tricky topic because we can't force someone into treatment. How I like to try to frame things is if the individual is aware, I am aware that so-and-so has been struggling with addiction. I am aware that they are struggling with their mental illness. And I will be supportive of them and I'll do everything that I can to help them. And that includes, assisting them in getting to appointments and assisting them in, in making it to whatever programs they can get into, and maybe even assist them in getting into a residential treatment program. So you can't sort of sweep this stuff under the rug. It has to be out there in the open. Again, the surety's obligations to the court to the accused have to be set out well in the affidavit, that the surety understands what it is they're going to do, and how it is they're going to enforce these conditions for the accused. One area I always find very tricky is with your surety, if you can get to them sooner rather than later, is whether or not they've spoken to the accused in custody. You know, have you spoken to this individual about the offense? Because that often becomes an area for cross-examination, right? Or you've talked to them, what did they tell you about it, right? So if you can, ideally get to them before and see if there's a way that you can prevent them from talking to the accused about the incident. I've had that many times where they've said, look, I haven't talked about it. I don't want to talk about it. That doesn't make them a bad surety that they don't know what this individual is alleged to have done. They need to know what the allegations are. They don't need to hear it from the accused themselves. So if you can, try to circumvent, I suppose, that aspect as well, because it is important, and it is ultimately protecting your client's rights as well. What else? Yeah. Again, if you can have a very detailed surety affidavit that can either, if you have an experienced Crown and you have a very forward-thinking justice of the peace, that will help to avoid any cross-examination or very prolix cross-examination. I've done bail hearings where the justice of the peace has interrupted the Crown when they were trying to cross-examine, and they've said, why are you asking these questions? Why do you think you need to ask these questions? It's all here in the affidavit. What exactly is your point here? If you're just asking questions for the sake of asking questions, I don't want to hear it. I don't need to hear it. So far, that hasn't led to any appeals, but you never know. But these are things that we all need to incorporate, I think, into our approaches and our practices. So I think I'll leave it at that for now and pass it on to my friends.
Okay, I feel like this microphone is really loud. Oh my God, I'm gonna sit this far back. So I'm Emma Haydon. I am the Crown representative on this panel. And I know that there's going to be a lot of questions about why are Crowns cross-examining sureties all the time? Why do you want to do it? In Toronto, things are very different from what, this is really, there's like a lot of feedback I'm getting here as well.
Yeah, we can turn ours off maybe.
It's just I can hear it ringing in the background. Maybe that's better.
What's that? Maybe she can turn it off. Yeah, and use mine that's further away. Turn yours off. Okay, try that.
Better? Okay. Technical difficulties. The bane of my existence as a lawyer. This doesn't happen in Toronto. This surety affidavit, like you've prepared, you know, the times that I see documentation like that is really when we're at a Superior Court bail review kind of level. In Toronto, and everybody here is probably mostly from Toronto, the reliance is on the surety declaration form, which we call it the surety affidavit, various things, but it's that very, in my opinion, bare bones type of form that, you know, really it provides you information about who the surety is, how much money they want to pledge, if they know that the person, what the charges are, You know, things that you kind of already know in a lot of ways. And so I find that when we're talking about from the Crown's perspective, what we use in Toronto, as far as surety affidavits and surety declarations, this form, it's missing sometimes a lot of those things that we may be interested in Crowns, as Crowns, in knowing about that particular surety. And so having you go through, that's the stuff I want to know. And when we are going into a bail hearing with just that surety declaration, we're missing all that stuff. And so I find that, you know, at least in my practice dealing with sureties, there are some things that I want to know that I don't get to know from the surety declaration. And that is usually kind of where the ground is fertile for me to think, oh, this might be somebody I want to be able to cross-examine. I'll tell you the things that I want to know. And look, I appreciate that there are probably other of my colleagues who are doing different things in show cause hearings. But I will tell you the things I want to know. I want to know, has this person been a surety before? Has it been for this particular accused? Has it been for another accused? And what happened there? Were there breaches? We are bound by Crown policy, and this is Crown policy in the prosecution manual that is available online, that says that any interrogation into sureties must be efficient, minimally intrusive, and focused on the specific issues that relate in the bail context. I think that you will find if people are kind of going outside of those boundaries, you will find justice of the peace who will intervene and say, no, that is not proper questioning. That shouldn't be what's happening. You know, even knowing some of these things, you know, let's say we were in this situation where we did get those fulsome affidavits. I think it would probably happen a lot less in our jurisdiction in Toronto that we would be having sureties come and testify in court. That's one way I think. I know that the previous presentation was about the Toronto Regional Bail Centre. Those lists are long. The ready to go bail hearing list is long. And lots of it is because there are sureties that we don't know that information about. And maybe if we knew that information, maybe if there's a different way, a different practice in terms of surety affidavits, adding that additional information, they might, for instance, end up as submissions only bail hearings, right? There are going to always be reasons where Crowns are going to be opposing release. Some of those are policy specific reasons. They are directives for the Crown's office about the types of offenses or the types of circumstances where we are opposing release for somebody. But in a lot of circumstances, it's because we don't know those things, and everybody is busy and overwhelmed, and we have many, many matters that are being addressed by duty counsel who are also very overwhelmed, speaking to people and trying to get these things ready. You know, sometimes I think if we had that information, it would be so much more helpful. I'm looking out, and there are many young faces here. I think many of you probably started practicing in the COVID or post-COVID time. I'm gonna date myself and wax nostalgic a little bit. I used to sit in the hallway at College Park and have conversations with sureties. And having a conversation with a surety who's proposing themselves, and obviously I would tell counsel or duty counsel, I want to have these conversations. I want to have these frank conversations with this surety about their supervision. You know, maybe this was somebody who had supervised this person in the past and it didn't go well, or they pulled the bail. And I just want to know why. And sometimes having that opportunity to just speak with somebody and understand, that changes your mind about what you need to do here, right? Because you've got the answer that you want. Do you need the answer to happen in court, you know, waiting for maybe a day or two or more for that person to be able to have the opportunity to be in court and giving you that information? No, really just what you want is the information. You just want to know. And that we don't do anymore. You know, I am the bail vetter on occasion at the Toronto Regional Bail Centre. I'm sitting at home in front of my computer, answering probably about 250 emails in one day, but I'm literally never talking to a human anymore. And sureties are a human part of this system. And I think that there is some space to try to figure out how do we treat sureties as appropriately as we're supposed to, keeping in mind what we're doing in the bail context, keeping in mind what the Crown policy is around dealing with sureties and how we're supposed to treat them, and knowing full well, and again, this is our Crown policy, this is the criminal code, and this is the law. I agree with her worship. Like, we have to start looking about what are all of the things that we can do before we get to the surety part. And maybe sometimes that's not happening. I probably am guilty of that too, right? Sometimes it's easy to kind of just jump and say, we just need to jump up the ladder, and there's that next jump up the ladder. But if we as Crowns have more information, that doesn't hurt. It doesn't hurt. And in fact, it probably makes things better, maybe makes things more streamlined, and maybe may end up with us taking a different position or saying we don't need to hear from a surety in court anymore.
So this isn't court, so cut me off because I know we have to get to questions. Okay, so I have so many. I actually hate this idea of this affidavit. I hate this idea. If you start giving all that information to Crowns, they're going to want to talk to people. And I think maybe in the instances of something really, really important, like, sophisticated drug trafficking charges, guns, where we're doing a special bail hearing. But honestly, I think that can cause I don't need that much information. I don't need that much information mostly. So let me go through some of the, there's a lot of things that have to happen first. First thing that we forget is, do we need a surety? And I've often do I need bail program? I've often had, bail programs all set up and I say no. And I think we get too used to just the sureties there. We might as well, what the heck, there, we've got one, let's use it. So first hurdle, do we even need a surety? And I want to kind of hear why we need a surety on this theft under. Yes, it's 26 theft unders. However, really, what's a surety going to do? The next thing I need to know is, I will often just ask defense, tell me about your plan, tell me about your surety. The nice thing now in Toronto is we get these bail packages. So for the most part, I can read about all of the allegations. I can look at the previous releases, and I can see the criminal record. I already have a pretty good idea about what might or might not happen next. And I already have sort of like, do we need a surety? Madam Crown, really tell me why, because I've read all of this. Unless there's something missing from the package, I need to know why we're even doing that. And then if we get into the rare instance where maybe we do need a surety, I can just hear from defense. You can tell me about this person. I don't know how many people in this room have actually been a surety. Anybody? Wow. Anybody ever have a surety? No. Oh, there you go. Perfect. Okay. So I have been a surety many, many times. I come from a family where you're either a surety or you have a surety. So when I became a justice of the peace, the best thing about it was I couldn't do that anymore. So sorry, guys, I'm not going to court anymore. Can't do it. I'm out. But what I'll tell you about having been a surety, but this was back in the days where everybody had a surety, everybody gave evidence, and it was really daunting. And I felt a lot like I was on trial. I didn't always tell the exact information about stuff, but the reality is, now I'm not related to very sophisticated criminals, so I'll just say that they're mostly a bunch of dumbasses, but I really didn't do anything. I signed papers and I left. I didn't do anything. I had nothing to do. If this dumbass is getting in trouble again, they're getting in trouble again. It wasn't like I could keep them from stealing again. And again, I'm talking about the low-hanging fruit. And so we really have to be careful that what is a surety really going to do? What are they going to do for this? If it's a house arrest, I get it. Okay. So now we're into some of the information we need. And this is where we get into trouble as well. So a meaningful connection. The number of times I sit there, well, how often do you talk to them? Do you know what car he drives? I want you to imagine that you've been asked to be the surety for your 25-year-old nephew, okay? So do you know what kind of car your nephew drives? Do you know what his girlfriend's name is? Do you actually know what he does? He probably has one of these crazy internet jobs that nobody even knows what it's called. But do you have a meaningful connection with this person? These are not things that help me. This is not a meaningful connection. The kinds of things we ask about are not meaningful. Let me find my place here. Okay. Do they understand the charges? Again, can we speak plain language to people? I know it's really hard for lawyers, but people sometimes don't know what charges are and convictions are. They don't remember stuff. They don't know what it's called. They can't remember what happened afterwards. Like these, again, these are not fatal things, and we shouldn't treat them like that in terms of crowns, right? I mean, they're just, it becomes a badgering situation, particularly when the Crown's already decided this person can't be released. And they can be the best surety in the world, and they can't be released. And that should be the argument. Why badger his mother about not knowing stuff, not asking stuff? It's not helpful to me. Yeah, we just have to be really, really careful about that. We have to be careful about, okay, do they clearly understand what they have to do? So I've had the situation where they get up there, it's like, this is a house arrest, this and this. Oh, really? Well, I can't do that. I have a lot of appointments. So please make sure as defense, you're going to get the answer that you want when they're up there, because that often happens as well. I want to go back to one that I forgot about. Oh, so what's a person of good character? Again, so subjective, it depends on how you grew up. Be careful with that stuff as well, right? That different communities, different ideas about what that is. You can have a criminal record and be a really good person. You can actually be an alcoholic and be a really good person. So just be careful with what good character is. Not everybody in the world is related to people who have money, who have space in their house, time on their hands, and are pro-social people. Not everybody does. But that doesn't mean you can't be a good surety, and maybe you don't actually need a surety anyway if you're not related to those people. So when we get into the higher level of supervision, this is where I do kind of want to hear, I want to know, is their loyalty to this person going to come before their protecting the public or their role as a surety? So will they call the police? And house arrest and those kinds of things, that is important. Are they going to be like, well, maybe I'll call him first and see if he's just down the street with his friends? That kind of stuff, you want to make sure that they do understand at this point, their loyalty cannot come first. So we're talking about gun charges and those kinds of things, serious domestics. And I think they also they don't have to believe the allegations, but they have to know that they're serious, and they have to know for now, well, this person's on this release, you do have to follow, they do have to follow the rules. So there's a lot of that too, about how do they believe it happened or not? And none of that I don't think really matters. They also, I think sometimes on defense has to be careful that sureties don't come with expectations about what bail is going to do. Because now he's going to get treatment, and now he's going to go do his homework. And so again, that's not the role of bail. And sometimes it's just, you have to be really clear that that's all great if you can get that done, it can help, but that's not why they're on a release. So that now you have all this control and make them do all these things, because probably if they didn't do it before, they're not going to do it this time. And then the finance piece. I think if they're on a $500 own bail, I don't actually care. I don't want to hear about their finances. When we get into big amounts of money, but sometimes I think if you're on a $500 own bail, do you actually even need a surety? I mean, I get it. It's so low level that I don't even know that we would need to do that. But in the event that there is one of those, I don't think we should badger people about their finances. It's embarrassing. I've had that done to me. It's intrusive, and it's actually not, it's so unnecessary. So just be really careful about, because systemically, if you create a situation where people don't want to come to court, they don't want to go on the stand and be a surety, then you know what? It works for nobody. It doesn't work for Crowns. Then we just put everybody in jail because we don't have any sureties to do house arrest. So to be mindful, they're not on trial. Be mindful that it's confusing. Not everybody knows legal terms, and so just make sure that, you know, if they need to come back, they will come back at some point, because you'll need them to. And I think that's probably, yeah.
I'm just a little bit surprised coming from the east, like Karen, like, can we bring you with us, your worship, to the east region? Because we definitely need these affidavits, I find, in Ottawa, and we almost always need sureties. I'm just surprised, so I'll just.
Back in the day, everybody had a surety, right? Everybody had a surety, and it was Crown policy, like on a domestic, if there's domestic assault, hands down, doesn't matter what it was, could be over the converter, could be, it can, no criminal record, always a surety. So back in those days, we did that. And the first time that I sort of went, really? The Crown, I've had several moments where the Crown's heads have exploded in court. And one of them was when I said to a very senior Crown in a special bail hearing, I don't need to hear from the surety. And the Crown almost lost his mind. It's like, well, I want to. It's like, but just to be clear, everyone, it is the JP's decision or the judge's decision, whether you hear from someone. And listen, if I make a mistake on that, let's sort it out somewhere else. Like, I want to know, because I want to know what the parameters are. But what I often say, I don't need to hear from them, or I don't need them at all. And let's see, let's let smarter people than me figure out whether I should have done that or not, and tell me. But as of now, I just do what I think I need to do, and I'll take direction if I get it.
Thank you. I'm going to read some of the questions and comments that we've been receiving online. I think, Karin, this is pertaining to a point that you made when you were presenting on surety affidavits or the plans. So we have a question here, or a comment, that usually if you try the here is my bail plan without surety, but if you disagree, here is one. The JPs say that it is not their job to come up with the appropriate bail plan for our client. It is up to the client or counsel to propose an appropriate plan, and for us to let you know if we agree or disagree with you, but we cannot go and choose which is best for you.
Sorry, I disagree with that. That's not been my experience. The justice of the peace knows what their job is. So, and I see some nodding heads over here in the room. So, whoever you are, I'm sorry that has been your experience. It should not have happened like that. Your job is to present the options, present your plan to the court, because the court can do whatever they want, right? They can say, I don't need a surety, or, you can get a situation of a bail set but not met, where they might say, you know what, I think you're almost there. If you can get me this, then I would release this person. So that's the only way I can answer that question. Others say, I'm sorry.
Thank you.
I have no comment. What another justice of the peace said. And what's over to you? I have no comment.
JPs on the regular indicate in a reverse onus, you must propose your very strongest plan, because if we reject your plan, you don't get to just propose a different one, even in alternative same hearing. So, and then, sorry, I think it's mostly comments here that we have.
On the reverse onus, I mean, people still have the right to a reasonable bail. So I honestly, the reverse onus, it's a great concept. Yeah, you should, you're back again. So, all right, it's more serious. But however, the same law applies. It's the same thing. You still get the most reasonable bail.
Your worship, I think some people want you to get closer to the.
Sorry, yeah, we're sharing.
Is there?
I'm going to hijack this for just a second.
Yeah.
I can't help myself. This reverse onus argument, okay? So the Crown says, oh, it's reverse onus. It's got to be jail. So we go up the ladder from the pit of doom, right? And the next step has to be a surety. Okay, for what it is worth, seriously, in Nana Bush, I said that's wrong. Okay, so my ruling is out there. That's wrong. Every case has to be decided on its merits. And there is not some reverse ladder one must descend just because it's a reverse onus situation. Take that for what you will. I haven't been overturned yet, not giving the Crowns any ideas. Okay, but there is authority out there and for that position.
Well, and the way that if you recall at Jarvis, and of course, Justice Jones never did this, but the Crown's caught on that when they did bring a 524 in front of me, now I had my chance and I can get rid of the house arrest or whatever it was. So the new trick was not to 524 and just bring the fail to comply. But that's kind of, you absolutely can and should look at maybe this bail was too tight in the beginning and maybe that is the issue.
And if, for example, the plan that is being proposed is too tight, will the JP ask questions about that and ask why am I giving that plan that is way too tight?
It depends on the JP.
I don't know if we have any question. Yes, I can see one.
Hello. I did want to ask about the surety plan, or sorry, it's called two different names, sorry, in the different jurisdictions, but the surety affidavit versus the plan. I did hear Her Worship's comments about, if you put certain information in there, it's going to push the Crown to ask the questions on certain areas in the affidavit. So I'm just wondering how you would decipher, I guess this would be for defense counsel, how you would decipher the information put in the affidavit versus the plan, or is it identical in nature?
So the way I view it is you can't pretend the issue is not going to come up, right? So that's why I would include certain information in the affidavit, because these are the things that, from my experience, and this is what the court wants to know. They want to know, if the person has a criminal record, that's got to be in there. By the way, that includes provincial offenses matters too. So speeding tickets, drive no insurance, all that stuff. I had a surety rejected because they didn't bother to go and get their license or something, and they had a driving suspension for whatever, but it was, oh, you don't follow court orders, so you're not a good surety on a POA matter. So just keep that in mind. Back to your question, sorry. Yeah, I mean, what I try to do in the affidavit, and again, I don't do this for every single case, right? It's really only for the very serious ones. To my experience, these are issues that are going to come up about the surety in terms of their ability to supervise, and what do they know about this person, right? Because you think about it, if you're running a bail hearing and the question gets asked, well, did you know that, this individual has prior convictions for drinking and driving? Are you aware of any problems with drinking? That's something you might want to explore, because if there's going to be a, surety, they may be in a position where it might be a good idea if this person has a very serious addiction. Are they going to be able to not have alcohol in their own home? That might be tempting to the person. If this is someone who has multiple driving convictions, are you going to have to, as a surety, are you going to have to hide the keys if you have a car? These are things that, again, in my experience, I've been doing this since 2005. These are things that come out that the court wants to know. Obviously maybe not your worship, but this is what I've had, and what the Crowns want to know. So it's sort of trying to cut all this off at the pass and say, look, this is all the stuff I think you want to know. I don't think I try to keep it as non-invasive as possible. And unfortunately, while we're trying to change the culture to make it a little bit more non-invasive, and we're trying to ensure that sureties don't feel like they're the ones that are under attack, because I've experienced that as well when they come forward to be a surety. You're trying to make this as seamless as possible. And if, like Emma said, if they can get this surety and this affidavit or some information in advance, maybe that will help them to say, you know what, I don't think I need to run a bail hearing. I agree, this person is a good surety. In Ottawa, we still actually do have those hallway conversations, and it's great. I'm often invited in with the surety. So it's me, the Crown, the surety, and they talk about it. I'm just there and answer the questions. And more often than not, you end up with a consent release, even on a very serious case. And of course, the difficulty are the challenges that everybody faces with respect to time and resources. And that's just the nature of this game.
I see, yeah, and Amanda Ross as well.
Thank you very much. I have a question that builds upon something that we've already talked about, which is the cross-examination of the surety on what the accused has said to them. And so I think we've probably all seen this in court where, the surety is asked, did the accused talk to you about what happened? If so, what did they say? I.e., did they confess to you? And if you haven't talked to them about what happened, you're this careless surety who didn't even care to inquire. And so I'm wondering if you can give some advice to maybe the junior counsel in the room. What type of advice should you be giving to sureties, to your client in advance of the bail hearing, keeping in mind that possibility? And what steps can you take in court, either through objections or submissions, to try to curtail that nature of cross-examination?
So, well, if they haven't talked to them about it, that's great. And I think you can prepare the surety to say, I didn't want to know about it. And there's nothing wrong with that. I mean, I don't know why people think you need to get up in everybody's business in order to do this, right? Like there's still elements of privacy and you don't need to know. You need to know what the allegation is. You need to know, is this something that I think I can handle? Is this some, do I think I can supervise this person? So that I think is the easier one if they haven't spoken to them. And you can prepare the surety to say, no, I haven't spoken to them about it. And then to me, it becomes an issue of submissions. It's not up to the surety to answer, why they didn't or whatever. And if you're defense counsel, I would object to that question being asked, any further information being asked about that, because it really doesn't, it's neither here nor there, right? You don't know. I mean, maybe the person lied. It doesn't matter what they said, because that's ultimately for a court to decide. It's not between this person and the surety. Where they have spoken to them about it, it's tricky. You can't tell the person to lie. You can't say we didn't talk about it. I think the only thing you can say is prepare them to say, yes, we spoke about it. And then if the questions from the Crown become a little bit too much, then you object and you just hope that you have a presiding official who says, I don't need to hear about this. Because ultimately, I mean, we all know hearsay is admissible, and I don't actually know if that happens as much anymore, where there are attempts to get information from the sureties. I mean, that was a thing when I first started, but I don't know what.
I think the Crowns are pretty good these days. I stop it just because, again, this is not a trial, it's a hearing.
Mhm.
It doesn't help me. I don't care if you talked about it or not. I really don't care. I mean, I can't think of an instance where it would matter. And then it becomes that ridiculous thing that sureties are stuck in all the time, which is, did you talk to them? You didn't. That doesn't make sense. That defies common sense. But you did talk to them. You're talking to them about crimes that they commit. So it's not helpful to me if I'm looking at the risk to the community and the plan and how it's going to work. That isn't completely irrelevant information. So I would shut it down, but Crowns are pretty good.
Yeah, I think that's changed a lot. I think there probably was a period of time where that was being done a lot more. I mean, it's not part of my practice. We have now these specialized bail teams, right? And so for the ones where there are kind of these more drawn out and significant kind of bail hearings where sureties may be questioned for a lengthier period of time in a special, for instance, those are being done by special teams of people who I think understand and have, specific training and guidelines about how they're running those show cause hearings. But, fundamentally, look, if I started crossing the line by doing that, sometimes you hear some answers, right? And then you ask the question because you think, I think maybe at some point there was this thought that Crowns were getting at what her worship talked about as kind of being one of the important things is how seriously are you taking these charges, right? And I think that sometimes those questions about did he talk to you about it, or did she or they talk to you about what they're charged with, maybe that was kind of the doorway you're kind of walking through, right? To being trying to understand, do you think that this is serious, that this person has been charged with this? And, what are the sources of information that you're relying on to think that this is serious? But, I probably wouldn't be too mad if I stepped over that line and I was told no, step back. And
I think as defense, just stand up and say, I'm not
Yeah.
sure how this is helpful to the secondary ground concerns or the plan. That should wake everybody up to where they're
I'm
going.
going to get to a question on there. Sorry. I just want to interject on this topic. There's a Superior Court decision from Justice Harris in this province, which says that generally speaking, that line of questioning is inappropriate. Okay, because it is an attempt to circumvent the accused person's right to silence at the bail hearing and allowed the Crown to basically weaponize the bail hearing to ascertain incriminating evidence. I can provide it to Mai, who can send it around to everybody later, but a tough sell in my court, to put it bluntly. Okay, I'm going to send this down as a question.
Thank you. Just a quick question. The idea of a surety affidavit is a great idea. It's a little bit, I think it'll be a little bit difficult for duty counsel to do this in every case because it does take quite a bit more preparation. But in terms of the rationale, in terms of bringing controversial issues to the fore right at the outset, I think it's a great idea. But as far as I can remember, duty counsel prior to COVID, your job was to run the Crown's case as well as present the evidence for release. So in fact, you would be raising these questions. And in fact, your job would be best accomplished as duty counsel or defense counsel if you were asking those tough questions such that there wouldn't be anything left for the Crown to cross-examine on in the first place. So, and I think that can be accomplished by post-COVID by doing that as well. So, just a comment as well as an observation for newer counsel.
Thank you. Is there another question in the back? I can't see.
Sure, yeah.
Okay.
So, in addition to speaking about prior criminal history or even POA convictions, I've encountered a couple of times now where I'm provided in my discussions with the Crown about proposed sureties, information about police involvement with the proposed surety under the Mental Health Act. I'm curious to hear thoughts from the panel of what role, if any, should discussions about previous mental health concerns play in either prepping a surety or during a bail hearing?
Sorry, do you mean that you're getting the occurrence reports from the police about the surety having been apprehended under the Mental Health Act?
Yes.
Holy, yeah.
Yeah.
So yeah, this is a real problem because I remember I was doing a bail hearing and the woman, the surety was an Indigenous woman, and I think it was her son. And they brought up not just a million police occurrences at her house where she had called the police. Her other son was autistic. She had a lot of issues with that child. And the Crown just went at her and it was just painful. And I kept managing it. And I just felt terrible for her. But in the end, when I gave my decision, my take on it was, here's a woman who calls the police when she needs them. Like, here's somebody who calls the police. She's got a son with problems. She's got a son who's autistic. She's got another son who's got addiction, the one that was the accused that day. And it was just, I felt horrible for her. She was badgered. The police have been at your house 80 times. And so that kind of stuff is coming up. And it is apprehensions under the Mental Health Act and peace bonds that their surety had 100 years ago, that, when they signed it, they said, there's no criminal record. Don't worry about it. Nothing happens with this. Just sign on the bottom line. And now they're a surety. And it's like, you've signed a peace bond 20 years ago with your neighbor. So that stuff is now, we have, the internet machine and everything's on it and everything's coming up.
Yeah, it's the internet machine. And this is something I've brought up in another context, specifically about Gladue reports. And I am aware of not all of the specifics, but about Gladue reports being used to question sureties. We obviously, as you now know, the Crowns have scope, and it is an online system that maintains our prosecution files. I think we have a lot of questions that we still need to tackle that we haven't yet in any detailed way about what to do with the fact that you know, effectively, I can look up somebody and see their entire history in scope since whenever that Crown's office may have come online in scope. And for instance, in Toronto, we're in our 12th or 13th year of having scope entries. You know, we have people who are often the people we see in our bail court with multiple informations who may have had 100 or more entries in scope. There's a lot of stuff in there. There could be a lot of stuff in there. And I think we need to start thinking about what are the right and wrong ways to be using that information, because, you know, you could, for instance, look up a surety in scope. I don't know what people are doing all the time. You know, there are some things that I hear about that I would never do in my practice as a Crown. I don't know why certain people do certain things, and you know, it shouldn't be that depending on which Crown you get, you're going to get a fairer shake at something, or somebody who's more reasonable or not going to do those things. But again, if any of my bosses are listening, I am speaking as a private person and not
It's
Attorney
Saturday.
General for the province of Ontario. But you know, it shouldn't be just because you get me, something's going to be different. But you know, sometimes that might be the case, again, because we are all humans, and reasonable humans can differ. But I think we do really need to start thinking about what are we doing with this vast amount of information that is available in a way that never used to be, right? You know, when I worked at College Park, before we even came to 10 Armory Street, we were our own pocket, right? I knew the stuff at College Park. I knew the files because they were all there for us. Now I know the files of every single office in the province of Ontario, because they are at my fingertips online. And I think we need to start thinking about that, because that stuff exists in perpetuity.
And I think that maybe it's just the world that I, you know, lived in, which is give as little information as you can. And I think that's what I'm so worried about this affidavit thing, is because just to do it all the time, just too much information. And I think it's for vulnerable communities, there just shouldn't be all that information sitting on paper somewhere, because it's going to come back and it's going to be used on you. So I think maybe, as I say, in those big cases, but just to do it all the time, first of all, there's no time, so I shouldn't be that worried about it. But if we did have the time and did it, I think it's dangerous to have all of that information on paper all the time.
Well, my view, until, you know, something changes, this is my defense lawyer perspective, until something changes on the other side, we're just the ones who are always reacting. We're trying to do the best possible thing for our client, and we're responding to the situation that we're getting. So it's awful when you have your client's surety up there and they're being asked all these questions, and either A, they don't know it's coming, or they don't know the answer, or they have no idea what to do with this. And you are stuck because you're in one of those rooms where you don't have an Emma Haydon and you don't have a Justice
So,
Roffey.
but hold on, I thought the affidavit was instead of and not in addition, because that seemed that, oh.
What do you mean?
I thought it was,
instead
I
of?
thought you used the affidavit instead of having somebody give evidence. No?
Not yet.
Oh.
No.
Oh,
Wouldn't that be nice? No.
No.
So the affidavit is I'm giving you this in advance as part of my, my defense side, bail hearing materials.
see, and maybe that's kind of a local cultural thing, because I would tell you that if I got all that stuff, I'd be like, oh no, maybe I don't need to do this anymore.
And you
right?
might
And-
get that on the day of your bail hearing, or you might be able to do that in advance, but
I mean, obviously subject to, they've put in there, I have no criminal record, and then we
Yeah.
do our criminal record check and something does in fact come back, right? I
Yeah.
mean, which we're doing regardless, outside of affidavits, if we have a surety file a declaration with their ID, you know, we're doing all that stuff already. So it's not like, it really helps us even further to have that information also in an affidavit.
Yeah.
I think, you know, there are things that we are not having in the paperwork that we get up front, which may, if we did include them, might be a little bit more helpful, and then maybe may streamline things, but in a kind of middle ground. That's not all of this information that you're expressing some concern about, but is certainly more than what we already get in a surety declaration. I think there's a space in there to have a little bit more information that gives the Crown what they need to do the assessment that we need to do, which is focus again on the grounds relating to release and being minimally intrusive. But that also protects, again, the privacy of the surety and doesn't take us down the road of you got to lay your life and your guts bare in a courtroom. Because, you know, people still, their privacy should be respected and people's dignity should be respected. And we should still, even as Crowns, show empathy for people and their situations. You know, dealing in a location like Toronto, we are dealing with a lot of people who do have many, many vulnerabilities and interconnected and intersectional vulnerabilities. And they've probably already had their lives picked apart by government. And we shouldn't do that anymore than we need to. I think we need to start really focusing again. And there's space in between what we do already in Toronto with those surety declarations and not as far as that.
Yeah.
To,
You still have to file the surety declaration. I don't think you
Yeah.
can get away from the surety declaration, but it's very bare bones, right? I mean, it's the name, the birth date, very, very basic information. And I'm sure if you tried to run a bail hearing just by filing the surety declaration, you wouldn't get past anything, I don't think.
it happens sometimes.
we do.
That's what we do in
Wow.
Toronto. And that's what or I mean, lots of times that's the consent. It's a consent with a surety and the information that gets provided then to you is the declaration. That happens sometimes too.
Yeah, I guess I'm thinking if there's a problem and it's in the surety affidavit, the Crown's gonna want to ask them about it. So I think to my mind, the best thing is for defense to prepare their surety and let them know here, they're gonna have problems with these things. And maybe it won't even come up unless it's in the surety affidavit. But just, I guess, I can't see doing both. That's.
It's just to be clear, what does your surety declaration look like? Because ours is like a one pager.
Nothing.
Yeah, that's all it is.
No,
No.
it's 2 or 3 pages long, but.
Is it even that long?
I think it's a standard across the province. It's the same one, but
Yeah.
we add the affidavits on top of that.
Yeah.
But I think the lesson of the day for the people in the East, maybe you should move to Toronto or to the GTA because there's no hope in the East. It's not
Listen,
going to change.
In places like, up north where before we had all the technology and they couldn't get sureties and they went purely on affidavit.
Mhm.
That's what they did. So you could do it.
And interesting things happened in COVID and all that stuff. A lot of the good stuff just sort of disappeared, right? We kind of went back to what we had before, unfortunately. Again, I don't know who makes these decisions, but not us.
Just before we get to the question, because His Honor, thank you. I just wanted to give the citation for the case that His Honor was referring to, and it's also in the chat. It's R versus KK 2019 ONSC 1578. So I'll repeat that, KK 2019 ONSC 1578. We'll take one more question before the break.
I wanted to ask if you had any advice or maybe guidance on when your client has a significant criminal record and you put up a surety and 100% of the time you get the question, have you talked to them about their previous offending? Both answers are wrong, right? Either you talked to them and they didn't listen or you didn't talk to them because you don't care what they're doing. Often I'll get some pretty harsh questioning following that on, why don't you talk to them? Why aren't you trying to help them? Or why don't they listen to you? You're not a suitable surety. And I'm wondering if you have any advice on how to either guide the surety into dealing with that kind of attack or on objecting to that line of questioning. I don't see it as particularly helpful. There's no right answer to it, but I've yet to have a case where it's not asked.
So what I have done, if this person has never been a surety for this accused person before, then I think that's where you want to focus. And I'm not really sure that in some cases the surety may not be in a position to say it like that, but it becomes more of a submission of, okay, well, this person has never been a surety before. They've never really had to do these things. Never had to ask this person all these questions. again, there's a lot of, as we've talked about, invasiveness of, getting up into somebody's business and why are you like this? Well, now I'm here. Okay. Now I'm going to supervise you and I'm going to do everything that I can to make sure that, that you follow your conditions. So I know I'm aware of what happened in the past. And now I'm looking forward and what can I do from here going forward? So that's if the person it's ideal if they've never been the surety before, because now they say, now my obligation is I'm sitting here, I'm telling you, I'm going to get involved. I'm going to find out, right? If they've been a surety before, then that's a whole other kettle of fish, right? Of what did they do? What did they not do? And that's more, I think, of a submissions issue and something that you would need to address with your surety as to whether or not they're an appropriate surety. If they have called before and here they are trying it again, well, then that's it. If they have talked to the person before about their situation and tried to give them advice, I think your fallback again is, at the time I wasn't their surety. I had given them my advice, but now I'm taking that a step further. And it's not just my advice, it's my concern. And now I am the person who is, I am the gatekeeper, right, between them and them ending up back in a cell again.
It's your job in submissions to tell me what you want me to do with that information. And maybe what you want to say is, in a maybe more precise or cleaner way, but it doesn't really matter. Like, here's the plan we have. Yeah, he's got a terrible record. But this plan is going to do this and that. And here's why, she didn't know about his record because they haven't spoken for a while or whatever, just explain it like you explain it. Like, why did you pick that surety and why are they there? So just tell me what you want me to do with it. Don't worry too much about those things because in the end, they're not really what's important about what we're deciding. So make sure you just make that argument to the JP or the judge that, okay, so whether they talk every week or it's really about the substantial likelihood most of the time, right? So just explain why the risk is not going to hit that threshold.
You have a 25-year-old accused and now you've got their mother coming forward to be the surety. And if she hasn't talked to him every single day and doesn't know what's going on, well, that's common sense. I mean, when you were 25, did you tell your mom everything you were doing? No. So, I mean, again, these are human beings in the room with us, and we have to at some point rely, there's got to be some common sense in this room, right? So please try to play to that. Remember that. The other important case you want to recall is Zora, okay? Zora about conditions, excessive conditions. Keep that in mind. I know I have seen some changes over the last couple of years that have been positive when it comes to that, but that's another one you need to keep in your little toolkit for your bail hearings.
Thank you very much. This was a very interesting discussion that we had this morning. So thank you for your time.